Hello, and welcome to our second webinar in this three-part series that deals with the most common warning signs that arise in construction projects. This webinar focuses on the construction program and deals with issues that can arise when they're not approved, not updated, or are just misleading. It follows on from design defects on site, here's how to respond, the first webinar, which you can find a recording of on our website or on our YouTube channel. Before we get into the substance, some introductions. My name is Richard Davis, and I'm the country managing partner of the United Arab Emirates, where BCLP has two offices, one in Abu Dhabi and one in Dubai. I'm also the head of BCLP's Global Construction Disputes team, which operates out of our hub offices in London, Moscow, the UAE, Singapore, and Hong Kong.
And my name is Richard Dupay, and I'm a senior associate in the Construction Disputes team and are based here in our Dubai office. Two quick housekeeping points before we kick off. Firstly, you'll see a toolbar on the left-hand side of your screen. You can use this to ask us private questions at any point throughout this webinar, which we strongly encourage. We'll get back to you with an answer as soon as possible. Secondly, there's also a handouts area where you can download our recent report, Spotting the Risks in Construction and Engineering Projects. Some of you may have already seen this report, which examines 10 of the most common early warning signs of construction projects. So today we're talking about programs, which fits into the wider topic of delay and disruption. It's no exaggeration when we say that almost all large-scale projects will encounter some form of delay or disruption. And that very much seems to be the picture around the world. KPMG's Global Construction Survey of 2015, which interviews over 100 large-scale project owners around the globe, found that only 25% of projects completed within 10% of their original deadlines, which means that 75% of projects were delayed for much longer periods. And it seems that the larger the project, the worse that the delays are. McKinsey & Company's 2015 study, The Construction Productivity Imperative, found that 98% of mega projects, defined as worth over $1 billion, experienced delays, with 77% of them experiencing delays of over 40% of the original timetable.
So in this 30-minute webinar, we'll cover the following topics.
The key features of a construction program, contractual and legal issues and remedies relating to the rate of progress and delay, how to defend against a delay claim, practical examples of how to manage program-related issues. We will cover these topics by continuing with our first webinar case study, the fictional Power Tower. Before we explore what went wrong with Power Tower, it is first useful to outline some key features of the construction program.
So the first point to make is that pretty much all businesses will be well used to working with programs and schedules and using them to arrange and plan themselves and their activities. And if that is a private internal matter, then there would be no issue at all. But construction and engineering contracts typically require the program to be shared with other parties, and that can expose a lot of detail, not just about progress and delay, but how much resource is actually committed to the project. That can be very revealing, perhaps for some people too revealing, about the contractor's approach to how they resource the job. On the other hand, it might be fair to say that a contract administrator or an employer has a legitimate interest in being able to review and audit the contractor's plans and its actual progress, and know up front, for example, how it needs to organize its own activities and avoid causing the contractor delays or giving it an excuse for delays, as some employers will see it.
That's right, and it's really that tension between those two perspectives that influences how parties approach programming issues. Added to that, as we all know, and as we will discuss later, the causes of a delay to a project is often an area that is hotly contested, and so the programs and updates to the program are rich sources of contemporaneous evidence. So fundamentally, this is why this is such a major issue, and why the parties' management or lack of management of the construction program can be such a potent warning sign for projects. Just to go through a few contextual points. The format of a program, the timing of its production, the level of detail that is contained within it, and how often it is updated is largely a function of the detailed provisions of the contract. In general, the modern trend is that programs are required to be issued in native formats so that they can be run and analyzed using standard software. The individual bars on a graph show the individual activities, and this takes you so far in understanding sequence and duration. But in native programming software, the logic links between activities are a key piece of the picture. These show whether they are what is known as finish-start dependencies, or no relationship at all between different activities, which is key to understanding the necessary sequence and the critical path of a project, which we will return to. In terms of detail, the FIDIC Red Book 1999 and the NEC4 forms of contract specify that the program should include the order in which the contractor intends to carry out the works and note the anticipated time for each of the activities. The NEC4 contract goes further and also specifies that the program shows key dates, such as the contractual completion date, and should include provision for float and time risk allowances, concepts to which we shall return. Most standard form contracts also require the contractor accompanying documents like method statements setting out a general description of the construction methodology, key stages of the works, and the number and class of each of the contractor's labourers and each type of equipment required for the works.
So drawing together these introductory remarks, we can see that there are really three purposes of a program. The first is as a monitoring tool, monitoring progress of the works. Best practice guides, such as the Society of Construction Law Delay and Disruption Protocol, which we'll refer to later, and the guidelines, for example, which accompany the FIDIC contracts, both emphasize that the effective use of programs will generally enable parties to raise issues early, which is notionally of a benefit to the project, and manage progress. But of course, they are also useful in allowing for early assessment of claims, which can be really hampered if the projects are inaccurate or are not updated. Secondly, as a planning tool, which is effectively the point we made earlier about the internal aspect of planning. It's not unheard of for a contractor to maintain its own warts and all internal records of progress in parallel with a more sanitized version that is issued and updated under the contract. We would not necessarily recommend that approach because of later disclosability issues, but it illustrates our point that programs and the data behind them reveal a hell of a lot of information, which some contractors, rightly or wrongly, fear might come back and bite them. And thirdly, in relation to dispute resolution, programs are a reference point by which to bring or defend a contractor's claim for additional time to complete the works. The analysis of programs and delay issues through various recognized methodologies is fast becoming a professional discipline in its own right, but it's at its absolute core, delay analysis of programs in dispute resolution is a way of collating, analyzing, and presenting enormous quantities of factual information. Whether that is less or more of a complicated and time-intensive exercise depends to some degree on how accurate, well-produced, and well-maintained the program data are.
Turning now to our case study, the Power Tower, which, as our previous webinar outlined, is a fictional and rather simple power station built here in the Middle East. The work consists of carrying out the detailed design and construction of the power station. Of course, there will usually be thousands of activities making up a detailed construction sequence for a project of this nature. For our purposes, however, we will deal with a simplified high-level version like this. The works were to commence on the 1st of January 2016 with the detailed design. The employer was to provide access to the site at the beginning of April 2016 to allow construction of the turbine hall. The program anticipates that by October 2016, the construction of the turbine hall will be sufficiently progressed for the contractor to be in a position to start the installation of the gas turbines and generators. In parallel, the contractor will construct the substation building. However, before the sensitive gas insulated switchgear and other equipment is installed in the substation building, the building will have to be temperature controlled to prevent the equipment burning out in the hot Middle Eastern climate. The employer is therefore to provide air conditioning to the substation building by 1st of January 2017 to enable the contractor to install the equipment. Finally, 6 months of commissioning can commence whilst the contractor completes installation of the substation equipment for completion to be achieved by 31st of December 2017.
So let's talk briefly about the critical path identified by a program, because this is at the core of delay analysis. Most people would identify or define the critical path as the primary sequence of activities through a project network from start to finish. The sum of the durations of all those activities basically determines the overall project duration. In other words, it drives the completion of the works. In general terms, if an activity is on that critical path, then it is likely that if it is delayed or prolonged, it will impact the overall completion of the works, which the contract will typically define with reference to either a specified date or an overall period of time starting with the commencement. By contrast, if an activity is not on the critical path and it is delayed or prolonged, then it might give rise to other consequences, but not critical delay that drives the completion date. So this is the critical path for the power tower. On this program, the critical path runs from the commencement of the detailed design through the construction of the turbine halls, through the installation of the gas turbines, and then through to commissioning. Now, it is worth mentioning that as a project program is updated, it is possible for the critical path of a project to change. This also has to do with a concept called float, which is in some ways the opposite of the critical path. Put simply, float is the amount of time which can be expended before an activity or sequence becomes critical to completion, either because more time that is critically required is built into that activity, or as a function of the space between that activity concluding and the next logic-linked activity needing to begin. It's often called FAT, as a rather unpleasant alternative name, but describes the same concept. Now, the existence of float, and crucially which party gets to take the benefit of the float, is sometimes a contentious issue, which we'll touch on later on. But first, we're going to turn to some so-called real scenarios.
So our first scenario relates to the approval of the program. It's worth highlighting at the outset that in most cases, the contractor's primary obligation is to achieve the time for completion, or what's sometimes called the completion date, either for the whole of the works or sections if the project is split up into sections. And in some contracts, we see specific obligations to meet particular dates along the way, which may have some incentive attached to meeting them, or, as is more often the case, a consequence for failing to meet them. So it's against that context that most construction contracts require the contractor to provide its first detailed program shortly after commencement of the works, or once it has been instructed to proceed. This period can be specified or might be a default period, and typically that program and its supporting information needs to be submitted for the contract administrator or employee's approval. What then is the significance of the program being approved?
Well, contractually, not very much. The program does not amend the contractual terms, including the actual completion date. So, to take an obvious example, an initial program that does not show completion occurring within the contractually stipulated time is likely, unless there are other considerations, to be rejected. But it might already show that there has been a delay event very early on in the project. A good example of that is initial site access, which is sometimes delayed and can have a knock-on effect. So that might give rise to an extension of time. An early issue like that can either be dealt with straight away or it can be left to fester. Now, in an ideal world, it would be dealt with in good time, but often we see the contractor or the employer trying to avoid facing up to those early delays or entering into blame games. And this really is an early warning sign for the entire project. So if the program is not accepted and the employer's team does not give solid reasons for not accepting it, then this could be a warning sign for the contractor. It might give rise to concerns about the employer's resources, but in most cases it will be an early indication that issues might get swept under the carpet and left to store up until the end of the project. And that can lead to an increasingly entrenched and defensive approach, which can derail the project. On the other hand, if a poor or non-compliant program is issued so that there are valid reasons for rejecting it, then that can be a warning sign for the employer as to whether the contractor is willing or able to commit the resources required to achieve the completion date. Now, the same can be said if no program is submitted at all by the contractor. If the contractor does not submit a program within the specified time, then in addition to whether that's a warning sign for the employer, which it often is for the reasons we've just touched on, there is also the issue of whether the contract provides the employer with any remedies for that failure. For example, the NEC4 contract provides that 25% of the price for the work done can be withheld if the contractor fails to issue that first program. We often see FIDIC contracts amended to allow the employer to withhold all payments until a conforming program is issued.
So some practical tips when dealing with producing the first program. The most obvious point is that a program should be submitted as soon as the project commences. And if this reveals that problems have already been encountered, then so much the better to start a constructive dialogue with the employer's team. If the program is rejected, the employer's team should give valid and robust reasons for not approving the program. For larger projects, it can be very helpful for the parties to discuss and agree in their contract or otherwise at the beginning of the project that a particular software is used to create and update the programs. Programs should also be shared in the native format and not in PDF, so that the employer's team can interrogate the logic links within the program. We mentioned float earlier on. Some contracts, the NEC4 for example, provide that the program should identify float, for which some contractors do not like because it provides the employer with more detail than they would like to give. Even the NEC4 though does not stipulate for whose benefit the float can be applied if the project gets delayed. It's a contentious and subjective issue to which there is no universally accepted answer. All right, back to the power tower. 6 months into the project, and the construction of the turbine hall had only just commenced. Now you'll see from the program, it was programmed to commence at the beginning of April 2016, but by October 2016, it had only just started. Since the construction of the turbine hall was on the critical path, the delay to the commencement of the turbine hall delayed the overall completion of the works. Let's break this down. So the turbine hall construction started 6 months later than originally planned, and so that activity finishes 6 months later than scheduled. The follow-on activity, installation of the gas turbines and generators, could not commence until the turbine hall was well developed. So 6 months delay to the turbine hall pushed the installation works back by 6 months. And since the installation of the gas turbine hall is delayed, so too is the commissioning of the power tower. All these activities are delayed by the same 6 months, and actual completion of the works was therefore achieved in June 2018, 6 months later than scheduled. However, the contractual time for completion remains the 31st of December 2017. So there is a 6 month gap between the time for completion and actual completion. What does this mean?
Well, this is a good point to outline how time is generally dealt with in construction contracts. Now, if there is no completion date, the default position under many legal systems is that the contractor would be under an obligation to complete the works within a reasonable time. That's generally known as time at large. Now, what is a reasonable time in those circumstances is hardly ever decided precisely because the vast majority of contracts do have a completion date or a time for completion. But there are some English cases that deal with those issues. They're quite obscure cases. Now, employers prefer the certainty of having a fixed completion date. We'll come on to the reasons for that shortly. But that supplants the implied position of time being at large and replaces it with an express contractual obligation to achieve the completion date. And we should add here that there's often an express obligation in construction contracts for the contractor to progress the works with due expedition and without delay, or words to that effect. Some contracts give an express right to the employer to terminate the contract after a cure period for a breach of that obligation. Subclause 15.2, subclause C1 of the FIDIC 1999 contracts is a good example of that kind of provision, but it also has a reasonable excuse caveat which limits its potency a bit, because a reasonable excuse for not proceeding with due expedition and without delay might be that the employer is responsible for a delay or a hold-up in the works. So, although it's a self-standing obligation, there can be a certain amount of overlap between it and the wider progress delay issues that the party might face if there is a delay to the project.
Now, if the contractor is delayed in meeting the time for completion, that is a breach of contract. Breach of contract usually means general damages which need to be identified and proven, and the usual rules that apply to damages claims also apply. But that is not usually the case in construction contracts. The pretty much global norm in construction contracts is for the amount of delay-related damages to be pre-agreed and stipulated in the contract, generally called liquidated damages. These accrue at a daily or weekly rate for the period between when completion should have happened and when it actually happened. In some jurisdictions, they would generally just keep on accruing, but in many regions, and in particular those which use FIDIC contracts, including here in the Middle East, they will be capped at 10% of the contract price. Parties are usually free to agree these kinds of arrangements, but they can be open to challenge. In common law jurisdictions, including in England and Wales, if the level of liquidated damages is found to be a penalty, then the provision might be unenforceable. In some civil law jurisdictions, particularly in the Middle East, the agreed amounts can be varied by at a court or tribunal's discretion so that they equate to the actual losses suffered by the party claiming them.
Now, the reliance or the prevalence of liquidated damages is by no means unique to the construction industry, but it is very well entrenched in the construction industry. And it's often argued that it benefits both parties. The logic goes, the employer does not have to go through the inconvenience of proving its losses in the event of a delay, and that can be very complicated. On the other hand, the contractor is able somehow to price its exposure to delay by knowing what the LAD rate, the liquidated damages rate, is going to be. But you could look at this in a different way. You could say the employer is quite fortunate, or employers generally are quite fortunate to be in a position where they're permitted by industry custom to recover damages even if they haven't actually suffered a loss or they can't properly prove what their loss is. That's a privilege that is generally not given, for example, to contractors when the shoe is on the other foot. What I mean by that is when contractors bring claims for the costs and losses associated with an extension of time, they often have to prove each and every item they are claiming. There is no industry norm that says that those damages can be pre-agreed. Also, in the real world, you do have to query whether contractors really have an opportunity to price the risk of delay based on the scale of the potential liquidated damages. Because if they did build that into their price, they'd be very lucky to ever win a tender. So this is also a bit of a contentious issue, and we rather suspect that the reason programming and delay disputes feature so predominantly in the construction industry is as much because of the existence and use of liquidated damages as anything else.
All right, so turning back to our scenario, the key question is which party is responsible for the 6 months delay? The contractor's primary defense to a claim for delay damages is that the delay was caused by an event for which the employer is responsible. Contracts will generally have a mechanism to extend the completion date in certain circumstances. If they do not, then under a number of legal concepts concerning the fact that a party cannot insist on strict performance if it has prevented the other party from performing, the completion date and the right to liquidated damages will probably fall away. So if the cause of delay is something that entitles the contractor to an extension of time, the time for completion gets extended and the right to liquidated damages is preserved, it just crystallizes at a later date. But if the cause of delay is the contractor's responsibility, then the time for completion will not move and it will be liable for liquidated or pre-agreed damages. In our case study, the contractor had not mobilized its heavy equipment to site, so it was unable to commence construction works until the turbine hall. However, the employer had also not given access to the site by the 1st of April 2016, which meant that regardless of the lack of mobilization, the contractor could not have commenced the works in any event. So we have two competing causes of delay, both of which are on the critical path. This raises a particularly controversial subject about how to deal with concurrent delay, a matter which most contracts do not deal with, and those that do often do so in an ill-considered way. For present purposes, we will say that the issue of concurrent delay is generally more relevant to money claims than time claims. In general terms, the industry consensus is that if there is true concurrency of delay, which incidentally the SCL protocol considers to be quite rare in practice, it should not have an impact on the contractor's entitlement to an extension of time. However, it might affect their recovery of costs. So in our scenario, the time for completion will be extended to June 2018. This means that the employer will not be entitled to levy liquidated damages for this delay because actual completion was achieved by the extended time for completion.
So for some practical tips around delay, when drafting or negotiating the contract, consider whether liquidated damages are appropriate for the project. This is not often open for discussion. As we mentioned earlier on, most of the standard forms provide for liquidated damages, and in some countries, including in the Middle East, for example, public tender laws often stipulate that liquidated damages for delay have to be imposed. However, where it is possible to have that discussion, it is obviously worth doing so. Secondly, as we said earlier on, delay does not normally entitle the employer to terminate the contract. There is this parallel obligation that is sometimes linked to an express right to terminate, but absent that, time in itself and delay in itself does not give rise to a default right to terminate. If a project goes really wrong and there is a cap on the liquidated damages which is reached, then the employer, of course, can benefit from inserting an an express right to terminate once that cap has been reached. Surprisingly, few of the standard forms of contract contain that kind of provision, but we very often see it added in. The success or failure of any claim for additional time or defense to a claim for additional time rests largely on the ability of the parties to prove their respective cases. So without adequate contemporaneous records, this is difficult to do and can otherwise undermine a genuine case. So both parties, and especially the contractor, should file and keep decent records. The SEL protocol advises that applications for an extension of time should be made and dealt with as close in time as possible to the delay event that gives rise to the application. A wait and see approach to assessing extensions of time is discouraged. This is also reflected in the standard form contracts, which envisage that claims for additional time are dealt with as the events arise. However, this is often not done, and that can lead to disputes over delay being left until the end of the project when records are lost, memories have gone stale, key witnesses have moved on, and other things that get in the way. And that can make establishing your entitlements time consuming and costly, more so than if you did it at the time. So our practical tip really for both parties to a construction contract is that the SEL protocol guidance is good. And though it may not seem so at the time, it really is best to try and resolve these issues promptly during the project if that is possible, given the dynamics of the project and the personalities involved.
All right, let's get back to our case study, the power tower. We're now 6 months into the project, and we know that there has been delay because of the late access and slow mobilization. Ordinarily, in such circumstances, the contractor would have to provide an updated program. The FIDIC 1999 contract provides that the contractor is to provide an updated program when instructed to do so by the engineer or when the previous program is inconsistent with the actual progress of the works. In other words, when there has been some delay. The NEC4 contract, by comparison, requires regular updates to the program, come what may. This is also what the SEL protocol recommends. Now, if the program is not updated, or it is not updated realistically, then it's difficult to assess the impact of new events or variations. And it is difficult to reassess the impact of earlier events, which is something that most contract administrators are obliged to do as the project progresses.
So in our example, if the employer wanted to increase the capacity of the power tower, say by instructing the installation of an additional gas turbine and generator, then let's say for the present purposes that it would add 6 months to the installation phase of the works. Based on the original program, assuming it has not been updated, so the baseline program as it were, the additional 6 months to the installation phase would push the time for completion out by 6 months to the 31st of March 2018. So 6 months would be added to the installation phase, which would also push commissioning back by 6 months, and then the time for completion would also be pushed back to the end of June. Now, this would actually not reflect the reality of the situation. As we discussed earlier, we know that the project was already in 6 months of delay at that point. So the reality of introducing a 6-month variation to the project means that the actual completion would be pushed back by an entire year. If we add the delay already incurred to construction of the turbine hall, installation and commissioning activities, plus the variation to the works, we can see that the actual completion date is a year later, at the end of 2018. Now, whilst this might be an extreme and oversimplified example, it does illustrate that when programs are not updated, it's very difficult to plan future events that might not be controversial, such as variations. If programs are not updated, it also limits their effectiveness as a monitoring tool. When delay occurs to the works, the contractor may be reluctant to share the true extent of the delay, or it might seek to manipulate the official program so as to hide its own delays and to avoid an admission that there has been a failure to proceed with due expedition and without delay.
That's right. Another reason a contractor might consider it to be in its interest to manipulate the program is to avoid an obligation to accelerate the works at its own cost to make up for the delay. So for example, subclause 8.6 of the FIDIC 1999 contracts provides that where actual progress is too slow to complete within the time for completion and the contractor is not entitled to an extension of time, then the contractor may have to adopt revised methods to catch up the lost time. This will obviously cut into its margin on the project and could have consequences that are not much better than paying liquidated damages in any event. Taking the power tower example again, if the updated program shows a delay of 6 months, 3 months of which are due to the contractor's culpable delay, the contractor may be expected to accelerate his works to catch up on the lost time. So if the program is going to be an effective management tool, it must be accurate and up to date. In practice, however, programs are often not updated and are not accurate. This can be for a number of reasons, but it's generally around the same themes we touched on earlier. Parties wanting to preserve their position and not make statements on the state of affairs that could come back and bite them. In an ideal world, the parties would be able to discuss program updates openly. We have seen one project in which it was agreed that in the run-up to the production of an updated program, the senior planners of the contractor and the contract administrator would meet on an off-the-record basis and have an open discussion so that the updated program was, in a sense, a product of some compromise. But those parties were getting on well and working under a framework agreement which encouraged a longer-term relationship between the client and contractor. Many projects will not have that luxury. For present purposes, we would always recommend to contractors that they should be wary of their dual obligations to complete the works by the time for completion and to progress with the works with due expedition and without delay. And if delayed by events that might trigger extensions of time, be very forthcoming and prompt with the information and substantiation. At the very least, this can help the contractor's position later on if a dispute develops.
So we have covered the role that programs play in construction contracts and in construction projects and some of the pitfalls that arise. We've touched on concepts like criticality, float, and very briefly, concurrency. So to sum up, I think we just emphasized that scheduling, programming, planning, call it what you will, is a specialist discipline with its own lingo and peculiarities. But although modern programming is typically software-based and involves a lot of analysis, it really is just a way of presenting a mass of information about progress. Construction projects generate a massive amount of evidence, and we've touched on some of the ways that contracts require the generation of that paper trail through programs and updates, how robust they are, and whether they are improved. Ultimately, a Gantt chart, the manifestation of a program, is a shorthand that claims consultants, tribunals, experts, judges have become increasingly comfortable with over the years. But like all fact-based evidence, it's meaningless if it flies in the face of common sense and has a healthy dose of credibility in its own right. And at the end of the day, a contractor who has maintained robust records, including through the programs it issues and their updates, will usually be in a stronger position to advance its claims and succeed if its entitlements are disputed than one who doesn't have those records. Conversely, an employer who has faced up to delays on a project at the time they arise and try to resolve them will probably be in a better position to manage the impact of those delays. So many of the obligations we've spoken about today are truly for the benefit of both parties. So thank you very much indeed for listening. We hope that you found this webinar interesting. If you would like to hear more about the topics covered today or any other construction related issues that you're facing, please do not hesitate to contact us on the details that are on your screen. And please do join us if you can for our next webinar on project management, which will be on the 20th of March. Thank you very much.
Thank you.